is evaluated by the legislature. So like our agency, one of the metrics that we're evaluated by is the applications. So if we are not processing a bunch of applications, then we get dinged for it.
Okay. I'd like to ask everyone to sit down and we will start this meeting. Today is Wednesday, April 9th. This is a continuation of the Water Quality Control Commission meeting to consider the water reuse rule. This is WQCC 23-84. We made a lot of progress yesterday, and I hope today goes as well. So we were talking when we finished yesterday. Before we do this, let's call roll. Okay, so Louis.
So a reminder to identify.
Okay. All right, this is Luis Lopez, the hearing clerk for the record. So I will call the roll now. Commissioner Brancard.
Present.
Thank you. Commissioner Frey.
Here, present.
Thank you. Commissioner Harms.
Present.
Thank you. Commissioner Laney.
Present.
Thank you. Commissioner Molander.
He's the one that's not here.
Oh, not here.
He's absent.
Chair Thompson.
Yes, I'm here.
Thank you. Commissioner Bayless.
Here. Present.
Thank you. Commissioner Vihil.
Here. I'm here.
He's trying to say something, but we can't hear him. That's what we need to figure out.
Okay.
Yes, Mr. Beason to turn his camera on so we can see him raise his hand.
Yeah, if you could turn your camera on, Commissioner Vihil, just we could see you.
We're gonna work on that.
Okay, we'll come back to Commissioner Vihil. Vice Chair Zemlik. All right, thank you.
Okay. Everybody?
And that's everybody.
Yep.
So we do have a quorum.
We
Mr.
do have a
Chair.
quorum. Commissioner Vihil is attending virtually. And have we established communication with him?
Yes.
Okay, we've got him. Okay, so we are in communication with him. That's good. And again, we've got a court reporter at a different location. So I've been asked to remind everyone when you speak, please identify yourself to make sure we've got a proper record. Okay, so what we did yesterday, just let me, kind of give a quick summary. We worked through, I don't have it in front of me. We worked through sections. Well, I'm sorry, I'm going to have to back off because I don't have it in front of me. But we were working on definitions. And we were working on definitions beginning with T. So according to my notes, we made it through treatment.
I'm not sure that you finished treatment.
No. I think it was transference that we're wrestling with.
This is Felicia Orth. The particular question that was on the table when we broke last night, it's at the top of page 20 of attachment A to the hearing officer report. The department's proposed definition of treatment is at the very top there behind the parenthetical. Amigos Bravos and Sierra Club proposed to remove the word transference, replace it with transfer, storage, and disposal.
I just have to go.
Commissioner Harms had pointed out that by replacing transference with transfer, storage, and disposal, what was being lost was if transference, the definition does not remain, is the word distribution and the word temporary in front of storage. So my memory is that
Thank you.
that's where the discussion was
I
left.
think that's correct. Thank you.
Be good with your daddy.
Commissioner Harms.
Thanks, Commissioner Harms. I am okay with the change proposed by Amigos Bravos and Sierra Club, as long as we add the word distribution into their proposed change. So I'm okay with removing transference and changing it to transfer, storage, disposal, and distribution. Thanks.
Further discussion? Okay, I'm seeing heads nod. Let's move on. Terms beginning with the letter U. Untreated produced water. Do we need that anymore?
That was in the definition of, this is Commissioner Fry, that was in the definition of domestic wastewater, which I believe we kept.
Yes. Yes.
Mr. Brand, our untreated produced water is, and treated produced water in 400 days.
Okay.
And Chair Thompson, this is Commissioner Fry again. I made a mistake. That was untreated wastewater that is in the domestic wastewater definition, not untreated produced water.
Yes. Are we comfortable with the definition of untreated produced water? I'm looking through my notes. Okay. Everybody agreed that that's the definition's acceptable. Untreated wastewater. Seems pretty straightforward to me. Okay, let's go on. Terms beginning with V, there are none. Terms beginning with W. Water contaminant. So
Are you gonna say?
Yeah.
water contaminant, we've got a definition proposed by the Environment Department. Then there's some suggestions by Amigos Bravo Sierra Club and CGF, CME, and New Energy Economy.
Chair Thompson, this is Commissioner Fry. I was just wondering, is the language beyond the first sentence necessary?
That's an interesting thought.
Mr. Chairman,
Yes.
Commissioner Brackard, this is actually a definition taken from the Water Quality Act, except for that last phrase beginning with the word but. That was added to the statutory definition.
Right, and this is a commission council. I was just going
There's
to
two
say
buts.
that I think to the extent that we should defer to
The
the
first-
definition in the Water Quality Act.
Both buts are taken, are added.
I'm sorry?
Oh, somebody tried to speak, but we couldn't hear them. Maybe that was Commission Council.
Good morning, this is Commission Council. Can you hear me?
Yes, not well, but yes.
Okay, yeah, I was just going to make that point that it's the water contaminants defined in the statute, so it should not be defined in the rule.
Did everyone hear? Commission council says, this is the definition that is in the statute. And so we should stick with the same.
No, I'm sorry, just so I'm clear, we should not attempt to define the term in the rule. We should defer to the definition in the statute.
Right. This is Katie, Commissioner Laney, excuse me. Sorry, I haven't gotten used to that. So you're suggesting it should match the others of similar nature where it referenced the specific statute.
Correct.
Commissioner Brackard.
So, Mr. Chair, council is correct, because if you look at the beginning of our definition section, it says that terms that are defined in the Water Quality Act but not defined in the part will have the meaning given in the act. So we don't need to have terms that are defined in the act, defined in here.
Okay,
And that may be true for the next definition too.
yes, I think so. So we should just eliminate this one completely.
Yes.
No,
That's,
eliminate it or refer to the statute.
At the beginning, as Commissioner Branker just said at the beginning, it says terms shall have the same definition as in the statute.
So I think this is Commissioner Fry getting processed down. That means we we leave the water contaminant in the definitions, but we refer to the statute. We don't give a definition.
We should not give a definition in the rule. We should just cite to the statute.
Yes,
so I
that's
think
my meeting.
this is, Mr. Thompson, I think Commissioner Fry is suggesting that that we leave it in the rule, just say as defined in the statute. Is that okay? All right, I see heads nodding.
Just to be on record, I said yes. Commissioner Fry.
Okay. And the next one, water pollutant?
The definition in the statute is water pollution. So it is a different word.
I'm looking at water pollutant, not pollution.
Correct. I'm just clarifying that what's defined in the Water Quality Act is the word water pollution. So it is different.
Thank you.
I have a question on that.
Yes,
It's, the word's different, but is the definition the same? Commissioner Laney, sorry, I forget that.
The water pollution is defined in the next definition on page 22. So right now we're considering water pollutant.
Thank you.
And Amigos Bravos has suggested that we just shorten it to pollutant as defined in 20.6.4 NMAC, which I think makes sense. Okay? Nod your head.
Commissioner Fry, that's what I thought council was saying, was the phrase water pollutant is not actually in 20.6.4, but the phrase water pollution is. Maybe I'm misunderstanding.
No, he's correct. But the definition of water pollution uses a lot of the definition of water. Water pollutant uses a lot of definition of water pollution.
This is the Commission Council. Just to be clear, water pollutant is according to the, I haven't confirmed it, is defined in the regulation. That's NMAC, not the statute.
Yes. And this is Chair Thompson. Again, the definition proposed by Amigos Bravos refers to the rule, not the statute. So we've got internal consistency. I think this is the way to go. Everybody agree? So for water pollutant, we will use the definition proposed by Amigos Bravos Sierra Club, water pollutant as defined in 20.6.4 NMAC. Okay, the next one is water pollution. And that's also defined in rule 20.6.2 NMAC. Anybody have concerns about that?
Of course, the definition in the rule copies the definition in the statute. So whatever. I think it's the same definition.
Would it be better to reference the statute rather than the rule?
I would think so.
The rule will supersede, I'm sorry, the statute will supersede the.
Yes.
Commissioner Laney.
This is Commission Council. We should always refer to the statute first.
So that citation, the statute is 74-6-2. So for the two that we're referring to the statute, 74-6-2.
Okay, so again, this is Chair Thompson. So we're going to modify the definition of water pollution to say water pollution as defined in 74-6-2 NMSA, which is a statute. Okay, wastewater. And similar to our discussion of treatment, Amigos Bravos is proposing to add transfer, storage, disposal. To the definition.
And this is Commissioner Fry. So as with treatment, then would we add distribution to that list?
I would say my suggestion would be yes, to be consistent with the previous language and also to strike transference. Okay, so is that clear? So again, this is Chair Thompson, the definition would read wastewater means water or other fluids associated directly with sewerage systems, industrial processes, or produce water that is disposed of or undergoes treatment for discharge, transfer, storage, disposal, or distribution or reuse. Period. Wastewater in this part does not include dairy wastewater. Commissioner Laney. Okay, so we've accepted the Amigos Bravos suggestion and added distribution and removed transference. Everybody in agreement? Okay. Terms beginning with the letters X through Z, there are none. Right? Any further comments on definitions? See if I have something. No. Okay, we go now to 20.6.8.100, which is general provisions. I'm on page 22 of the hearing officers attachment A. So I think everybody can see that Amigos Bravo Sierra Club has proposed striking out the last sentence, which refers to regulations associated with spills, notice of intent, permitting fees, penalties, and so forth. Comments, thoughts?
This is Commissioner Harms. I agree with the proposed change by Amigos Bravos and Sierra Club.
Others? Commissioner Zemlik.
This is just, yes, this is Commissioner Zemlik, the deep sigh. This is a larger question that's just, I've had sort of since yesterday. So, through the NOI process, you can have, notices of intent applications that are denied. And with what's proposed here, you can have notice of intent applications for pilot scale projects that may need a discharge permit. But what is, and this is sort of where the unauthorized applications fits in, how is that enforced? I don't understand how that is enforced because there's not a permit. My own rudimentary understanding of how we deal with NOIs at the office of the state engineer, there's a different process. And so I'm just trying to understand what that would be when that happens at an authorized location that has an unauthorized activity.
I don't. Commissioner Harms.
I think this falls under, I mean, if you have a bad actor who is lying and committing a violation, an environmental discharge that has not been authorized by the department, that would go into the normal court proceeding, a notice of violation. You know, it's not in my wheelhouse to know the exact details of that. But my understanding is if anyone on the street, you know, is illegally discharging, we have ways to call that person into account. But I agree with your point. I mean, it's not as strong as if we have a normal inspection compliance program in place.
Thank you, Commissioner. To follow that up, and I wish we could ask questions of the audience, because I know that the NOI process is what has been used historically. And this is sort of strengthening that and, adding a little bit more meat to it. But I don't recall hearing in testimony that there was any action taken against current NOI operators under the past system for, I don't know if that's district court. I don't know what that is. And so I'm a little bit concerned that that we're not considering that, because we cannot, the department cannot then go and pull a permit. It's a legal action.
Yes.
Commissioner Brankard.
Mr. Brankard.
I think we should deal with this when we get to section 400, because I think that, and again, I'm kind of on a stretch here, but I believe that we have stated at the beginning of section 400 that it's subject to both the Water Quality Act and the Produced Water Act. And so I think that we are, in a sense, creating a new notice process under section 400, and that we're not strictly bound by the 1201 process in the groundwater regulations, that this is a new process. And if we want to tweak that in a way that it looks more like an approval rather than just go do whatever you want, I think we can do that because of the Produced Water Act. That we're not totally bound by the groundwater regulations in section 400. This is generically talking about all water reuse, this provision that we're looking at now. Which, yes, all water reuse should be bound by the groundwater regulations, but produced water reuse is also bound by the Produced Water Act. So I think we have more flexibility in section 400. That's just my opinion.
No, thank you. I appreciate that.
Okay, so we're back to general provisions. Do we want to leave as is, or do we want to accept the suggestion by Amigos Bravos Sierra Club? Commissioner Brankard.
I would go with the Amigos Bravos. I don't think it's necessary to have that sentence in there.
I'm seeing heads nod, so
Yeah.
We'll strike the second sentence under general provisions. 20.6.8.101. Yes, this is one that I had some concerns about. 20.6.8.101 deals with unauthorized applications of reuse water. And this is a proposal to prohibit discharge reuse water for potable applications, which is domestic wastewater reuse. And I'm concerned about that because there are a number of communities that are proposing wastewater reuse. There's one community, Cloudcroft, which has an actual plant built. I don't believe it has been started up yet, but there is an actual reuse system that has been constructed. And as I read it, this provision would prevent reuse of domestic wastewater. So I'm concerned about this one. Commissioner Brankart.
Mr. Chairman, I think what they're trying to do is take the provision in section 201A and sort of copy it and move it to 101 so that it applies to all reuse as opposed to 20 one, which is under domestic water, wastewater reuse. I think what they're saying is that it's just sort of a how you classify your provisions here. That sections 100 plus are general provisions applying to all water reuse, and sections 200 plus are just for domestic wastewater reuse, but yet in 201, there's a generic statement about authorized potable applications for any kind of water reuse. And they're saying, therefore, that statement should belong in 101.
Yes.
So this is not new language, it's just sort of copying the language that's currently proposed in section 201 and moving it to 101.
Yes.
I think that's what's going on.
I think so too.
So this is Commissioner Fry, and so if that is what's, I agree, that's what they're proposing, to move it from 201 to, where are we here? 101. But they only take that top paragraph. Why do they not include the authorized application paragraphs in moving that over?
I believe because those authorized applications only deal with domestic wastewater.
In the change that is proposed, it does, yes. They propose changing that to domestic wastewater.
So again, I don't think we need the language proposed by Amigos Bravos for 20.6.8.101. What's the thoughts on the commission?
I don't understand, this is Commissioner Zemlich, I don't understand what it accomplishes. I don't understand the intent.
So Mr. Chair Thompson, I propose that we not include this language. I'm seeing heads nod. All right, let's move on. 201. Again, so we're now looking at section 1.6.8.201, which deals with direct and indirect potable applications. Again, I'm concerned about this because this appears to prevent direct potable reuse projects.
Mr. Chair?
Mr. Brancard.
I think you're correct, but let me raise a real sort of geeky lawyerly issue here. The sentence starts with the words "the department." Okay, the department is defined in this part, 20.6.8, as the Department of Environment. Okay, under the Water Quality Act and under the groundwater regulations, the implementing entity is the constituent agency that is appointed by this commission. So it could be Department of Environment, could be OCD, could be State Engineer, could be Department of Agriculture. At this point, it's just OCD and Environment Department, but it's not limited to the Environment Department. This definition of department equals Department of Environment makes sense for section 400 because the Produced Water Act says that it has to be implemented by the Department of Environment. Okay. So that sort of amends what the limits what the Water Quality Act can do. It's just the environment. But generic water reuse could be implemented by the constituent agencies of the commission. So if you have water reuse at a refinery, that should be implemented by the Oil Conservation Division. So that's my concern with using the definition of department equals Department of Environment for the water reuse provisions as opposed to the produced water provisions.
Chair Thompson, this is Commissioner
Commissioner
Fry.
Fry.
Since we define it at the beginning of the rules as department means New Mexico Environment Department, I don't have a problem just using the word department and understanding that means NMED. So if it would refer to a different department, then we should state what that other department is.
Right, but if you go to the Water Quality Act regulations, which it says we're subject to, it says department equals the constituent agency appointed by the commission. It doesn't say department equals Department of Environment. Right? So we have OCD, who is assigned to regulate oil and gas related facilities like a refinery, right? And so if there's water reuse at a refinery, OCD should be the one implementing this part of the regulations, not the Environment Department. Now, given how little there is in this rule right now, I doubt it's going to impact OCD's jurisdiction over refineries and other oil and gas related facilities. But I think going forward, the Environment Department needs to clarify that if you're operating just under the Water Quality Act, it's implemented by the constituent agencies. If you're operating under the Produced Water Act, it's implemented by the Environment Department.
The Chair Thompson, this is an interesting wrinkle, and I see your point. I don't know how to address that because this rule was in response to direction provided by the legislature under the Produced Water Act, rather. And so it seems like it only refers to reuse applications that are subject to the Produced Water Act.
Mr. Chairman, I think the Environment Department made it quite clear that this is way broader than that. That this rule, this part applies to all water reuse. Now, all we have really in terms of substance for the other kinds of water reuse is section 201. That's the really only substantive provision related to any other water reuse other than produced water. But their goal is for 20.6.8 to apply to all water reuse and that produced water be simply a subset of water reuse. They didn't have to do that, but that's what they did.
And this Chair Thompson, but section 201 only refers to potable applications, which are under jurisdiction of the Environment Department. So I don't think the complexity, I understand the complexity and I agree. It may be a problem in other sections, but in this section, I don't think it's relevant.
It may not be, but I think going forward, in terms of water reuse, it needs to be clear that department means whatever constituent agency is designated by this commission. Except for produced water, which is just the Environment Department. Okay? That's the tricky thing here, is that the legislature in creating the Produced Water Act specifically delegated it to the Environment Department to implement it under the Produced Water Act.
Yes. Again, this Chair Thompson, I think you might run into that problem in section 300 when we're talking about industrial wastewater reuse. So for instance, if we were going to use it for a manufacturing process or a power plant or something like that, conceivably it could be subject to rules under OSHA or something like that.
Well, this, I'm sorry, but just to go back in history, 40 some years ago, this commission issued this sacred document called Delegation of Responsibilities, which divided all the activities under the Water Quality Act between what was then the Environmental Improvement Division of the Health and Environment Department, and the OCD. And essentially, oil and gas related activities that are not covered under the Oil and Gas Act are subject to Water Quality Act regulations by the OCD using the Water Quality Act rules. And the specific example of that are refineries. Refineries have discharge permits issued by the OCD. Okay, not the Environment Department. So they're acting under this document, which is not a regulation, it's just a piece of paper that is a delegation of responsibilities, which is our duty under the Water Quality Act to delegate responsibilities to the constituent agencies, of which every agency that is sitting on the commission is a constituent agency. Sorry for the history lesson.
No, I appreciate it. Again, this Chair Thompson. Again, I think that's an interesting issue. Who has responsibility in some of these other uses, but Section 201 is for potable applications. And that's the Environment Department. I think we should deal specifically with that. We should accept the use of the phrase "the department."
Okay, so just to clarify, under the Water Quality Act regulations, department is defined in 20.6.2. It means the New Mexico Environment Department or a constituent agency designated by the commission. This is 20.6.2, the water quality rules.
Yes. But in this rule, we're defining the department means the New Mexico Environment Department.
Right, which I think is based on the assumption that's what the Produced Water Act says. It's not what the Water Quality Act says.
So are you suggesting we go back and revisit the definition of department?
Yeah, I mean, I think we can do that now, or next time around with the next rulemaking, the Environment Department can clean it up. This water reuse stuff is just not that big a deal, as you pointed out.
Chair Thompson, I just wanted to offer another reason to expand the definition of department. I think the strategic water supply includes a number of departments. And I think even though it's not what was signed this past legislature, I think produced water is may eventually be re-included, and that includes the three constituent agencies of OCD, NMED, OSC.
I agree. So I think I heard Commissioner Brancard say that he's comfortable with leaving the definition of the department as is in this rule, but asking the Environment Department to clean it up in subsequent submittals, particularly when we deal with industrial reuse.
That would be fine, Mr. Chairman.
Okay, so let's go back to 201.
And I'd like to comment on that.
Commissioner Fry.
On your concerns, Chair Thompson, this is Commissioner Fry. So I don't have a problem with Section A because it says, shall not approve a discharge permit or discharge permit modification, jumping to the end, except for those authorized applications identified in subsection B of 201, which if you go to B, then it lists feasibility studies and the allowance or authorization for some different activities. So I don't see a problem with that first paragraph.
Chair Thompson.
Commissioner
Fry,
Zemlik.
I have a question. The way that I read it is the authorized application is a feasibility study. Anything beyond that seems, even though it does specifically say that the approval from the department, discharge permit, and maybe the intent is that you do a feasibility study in order to get a discharge permit. I just wanted to raise the concern that it shouldn't be limited to feasibility studies.
And I would agree with your interpretation. Right now, the only listed activity is a feasibility study, with then breaking it down into what is appropriate under that.
Okay, and again, this Chair Thompson, my question is Cloudcroft has got a facility that's constructed. They could probably turn the switch on and start it within a month. As I read this language, it would not allow that.
Yes, that's the way I read it too.
I would agree, because it's beyond the point of a feasibility study.
This is Commissioner Fry. So how would we change that title, and can we allow anything beyond a feasibility study?
Mr. Chairman,
Commissioner Brankart.
I guess I'm a little concerned here about the record in this hearing. I mean, I believe it was the testimony of the Environment Department that while they have 95 discharge permits for water reuse, that none of them involve potable water.
That is true.
Okay. And so this is as far as they're willing to go with potable water, and that's what they testified to. We really don't have evidence in the record that would support anything more than that. Thank you.
Yep. I probably shouldn't say anymore because I've been involved with Cloudcroft for 15 years and that information was not included in the record. And I'll leave it at that. So if that's the case, do we want to change 201 section A, which states that the department shall not approve discharge permit for direct or indirect potable reuse?
Commissioner Bayless here. I think we should.
So, excuse me, Commissioner Bayless, you're saying we should approve the language as written?
No. I'm saying we should allow for the direct use of potable water and not get in the business of prohibiting it.
And Commissioner Bayless, just for the statement of reasons, that's what I'm taking notes for, to prepare a statement of reasons. What in the record would you point to as a basis for that decision?
Don't know that I can answer that.
Well, I, I agree. I can't point to anything in the record that would argue in favor of allowing direct or indirect potable use domestic wastewater. I think that's a pretty significant oversight, and I would encourage the Environment Department to address that as quickly as it can, because as I said earlier, there are a number of communities that are looking to this as an opportunity for supplementing their water supply.
Commissioner Bayless, the question is, by indirect, do we mean in possibly injecting treated wastewater into an aquifer and then going down gradient and use that aquifer as a source?
That's correct.
And that's what's being done in California?
It was not discussed, it was not presented. I'm not aware of any testimony or exhibits that dealt with it during the record. But it's being done many places. And I'll end there.
Commissioner Bayless, and the way it's written, this language would not allow that in New Mexico?
That's my interpretation.
Well, I think you're right in recommending that NMED address this, because it's not according to conventional usage right now. And to disallow it is really stupid.
So this is Felicia Orth. As I understand it, at some point there was an acknowledgement that we are heading toward a time when the science or the data will support a potential application that way, but we're not there yet. And that's why the feasibility studies in B. So it's a prohibition except as in B. And then they'll have the information they need to come back to the commission after they have some feasibility studies. That's my memory.
Another question. Commissioner Bayless, are not injection into aquifer of treated wastewater, is not that being considered in other communities? It seemed like I remember Rio Rancho and other locations.
Yes, that falls under the Aquifer Storage and Recovery Act, administered by the Office of the State Engineer. I believe there are 4 projects, ASR projects, or USR, Underground Storage and Recovery projects, that are approved by the state engineer.
But they need a discharge permit from an MED.
They need a discharge permit from NED. Yeah.
But it would seem to me, because I agree with Commissioner Bayless, this is Commissioner Zemlich, I agree that that's the low hanging fruit in all of this, and it's frustrating that it's not addressed. But it also it's maybe the light here is that feasibility study doesn't have a limit on the amount. And so conceptually, you could have an approved feasibility study that is something like that, that does have a discharge permit through this section 1 feasibility study that can operate for a period of time, prove that it works, and then, you know, have some mechanism to continue on with that, the way that I read it.
Commissioner Brancard.
Well, I guess I would say this is why I proposed the sunset to apply to the entire park, not just the produced water part. Because the question I think that Commissioner Zemlich brings up is implied is what happens if the feasibility study succeeds? Then what? I guess do another feasibility study?
Just as,
So
like,
hopefully the department will come back with rules that, you know, that will allow this to go forward. I mean, if the feasibility study shows that you can do this, you know, I mean, that's the point of the feasibility study. It's more than just, you know, a laboratory test on produced water. It's a bigger deal.
I agree. You said something that concerns me. First thing we did yesterday was we passed 20.6.8.4, which was the duration. And that was the duration for the entire rule, right? Okay, you just said a minute ago that it was, I think you said that it applied only to the produced water.
That's not what he said.
Okay, all right. Then I was confused and I apologize. Let's go on. So we're dealing with section 201, direct and indirect potable reuse. It seems like the commission, the sense of the commission is to allow it to stand as written. I'm watching your finger, Commissioner Laney.
Yes, we, through the record, didn't hear any testimony nor evidence regarding domestic wastewater reuse. We only heard testimony and evidence regarding produced water. And this is separate from that information that the commission has heard and been provided. So while I agree with some of the argument and comment here, I don't think that we can speculate based off of the information that was presented during the duration of this. So I think we should proceed with the definition as is or closely thereto.
Other commissioners? I see heads nod, so we'll move on. We'll allow it to stand as written. We'll go on to section 20.6.8.300, which is industrial water reuse. It is reserved. And then we go next 20.6.8.400, which we had rather extensive discussions on yesterday. And so let's start with section 400 as provided in the Produced Water Act, subsection B of section 70.70-13-3 NMSA 1978. The following provisions apply to the discharge of produced water for activities unrelated to exploration, drilling, production, treatment, or refinement of oil or gas.
I would propose to accept the Amigos Bravos changes right underneath that
Yes.
to include the Water Quality Act.
That was Commissioner Zemlich.
That was Commissioner
I'm sorry,
Fry.
I'm sorry. I apologize.
but I'll agree with Commissioner Fries, Commissioner Zemlich.
Commissioner Brancard.
So, Mr. Chair, I think we made some modifications to these sections here. And I believe, in fact, I believe you, Commissioner, and had that in the Water Quality Act. Here.
Yes.
And I believe we
demonstration.
All through this, replace demonstration projects with pilot projects. Okay, and we also deleted industrial projects.
This is Chair Thompson, that's correct. We added the reference to the Water Quality Act. We initially allowed demonstration projects. We subsequently changed that to pilot projects. Commissioner Zemlich. Oh, she's reaching for her phone. I'm sorry.
Fine.
As I've said yesterday, I'm watching people's fingers, and when they start to reach for the microphone, I assume they're intending to make a comment. So is everyone comfortable with the introductory section 20.6.8.400 again, as we amended it yesterday? I'm seeing heads nod, so let's move on. So under general requirements, we've got A1, which deals with untreated produced water discharged to surface waters. And, you know, to paraphrase, it basically says that it shall not be allowed, no discharge to surface water. Does anybody have concerns about that language? I think there's universal agreement that produce water is not suitable for discharge to surface water. Although in reading the record, the summary comments by Namoga mentioned that produced water from the Raton basin is better quality than some of the surface water. I thought that was interesting, but I do not personally support discharge of untreated produced water to surface water.
That is from coal bed methane.
Yes, it is, but it's still produced water.
Yes. But I agree with you.
Okay, so let's move on to
No,
Commissioner Fry.
he's been hovering over his, and I've been waiting for you to complete your comments. So, on this section, there are several comments from all parties.
For A1?
Yes. It
Yes.
seems A1 through 4, so it seems like we should review those.
Yes. I was going in sequence. So A1.
So actually, I don't understand the changes proposed by NEE. I haven't looked at those closely enough to see how that differs from what's there already. Namoga adds in, let's see here, no person shall cause or allow untreated produced water to discharge so that it may move directly or indirectly to a surface water of the state as defined in paragraph 5 of subsection S of 20.6.4.7 NMAC. I don't know if it matters, but nevertheless, we do have this other one from CGFCM that I have not dug into yet. And I'm wondering, Madam Hearing Officer, if you have a feeling for what they're suggesting there.
I'm sorry if I understand your question. they had extensive argument that the rule should not be adopted at all without a prohibition. And so they are, again, sticking by the recommended prohibition, but maybe I didn't understand your question.
I was just saying, I haven't been able to dig into how they're changing section A. But it looks like, just looking at it quickly, they're rearranging the order. And I'm referring to the changes listed on page 28.
Right. So I'm sorry. Your question is, how are they saying something different from Amigos Bravos? How are they saying something different from the
NMD,
department?
From, yes, the department.
Yeah, so I remember doing this. This was tricky because they changed the order of the paragraphs and just rewrote it. Entirely. So I had to show it, fully underlined. It wasn't a question of them changing a phrase here or there. I can go to, so I cite the places in their closing argument, their joint closing argument. We could look to that. I have it in front of me. Let's see, pages 1 through 14. In the Center for Biological Diversity Guardians and Frontline Community Members, and then NEE, pages 1 through 10, 14 through 20, and 32 through 38. So I'll just hit the kind of the highlights here first in Center for Biological Diversity, Wild Earth Guardians, and the community members. They again exhort the commission not to adopt the rule without a prohibition. They do support well-regulated demonstration projects. They don't believe the proposed rule is based on best available scientific information. The science isn't there yet. Produced water has not been characterized sufficiently to create standards. It's highly variable, which complicates that. Contains unknown contaminants, no adequate testing, no adequate treatment protocols. Almost done here. Existing water quality standards are inadequate for produced water and more research is needed. So those are all of the reasons up, and I'm not repeating all the other reasons industrial reuse, industrial projects shouldn't be done. So that was in support of their general prohibition. but the question as to why they rewrote the specific language going to the prohibition and changed the order of the paragraphs, I'm not sure I can answer that sitting here.
Excuse me, this is Chair Thompson again. In the interest of moving along, there was, we're dealing with section 400A1, discharge of untreated produced water. The one suggestion that I thought was worth incorporating was by Namoga, which referenced the state, the regulation 20.6.4.
Having looked at the other proposed changes to A1, I would agree with you.
Okay. Do we want to include the reference to 20.6.4.7 or just leave as is?
This Commissioner Braga, there's a definition of surface waters, which in the definition references that other definition. So I think it's unnecessary.
Okay. So I think I'm seeing heads nod. We're going to leave section A1 as suggested by the NMED. We're not going to include reference to 20.6.4.7 NMAC. Okay, everybody agree? All right, let's move on. Treated produced water discharged to surface water. Okay, and here we were, I think the language suggested by NMED was I had suggested, and I think I got this from Namoga, except as otherwise provided under this part. And that language is to allow discharge permits for pilot plants, pilot projects. Otherwise, I'm comfortable with the language.
Chair Thompson, I wanted to get a little clarification. We yesterday discussed that very thing and voted on it. I may have recorded this wrong because who knows if I was getting that down right, but in my notes, it was the exemption is kind of a strong word, but under 4, so A4, did I record that incorrectly? Is it going to be A2 and A4?
Commissioner Laney, you're suggesting that we were going to combine 2 and 4?
No, could we have that read back what we did yesterday? I think that would be helpful for me understanding. I was trying to understand from my own notes and it's not helpful. So could we hear what we did yesterday specifically with this area and providing that allowance for pilot projects? Thank you.
Sorry, can you be more specific? What? Okay.
Commissioner Laney, so yesterday, as part of we started with the 3 questions, and as part of question 2 and question 3, we debated the allowance of pilot projects to be, have some aspect of discharge given a permit, of course, but I can't remember the specifics of that motion and what it included, and I was hoping you could read that back.
Okay, so I might have to do this in pieces. So on
Perfect.
page 15, in the definition of pilot project, my note shows that we deleted beyond the bench scale because bench scale's been removed, industrial's been removed, demonstration's been removed, you're left with pilot project. Is that your question?
Yes, and then what was the next part of that motion where we voted to include under section? I had wrote it down as A4, but I'm afraid I may have recorded that wrong. I just want to confirm what was done, please.
Mr. Chair, since I made the motion, I have it written down here, and Commissioner Laney is correct. I simply referred to A4. I did not refer to A2.
So then my question is, are we allowing that exception in A2? Should we allow that exception in A2, which is surface water, as we allowed it in A4, which is groundwater? And I'm just curious, we need to further change this section.
Good question.
Chair Thompson?
Commissioner Zemlik.
I believe this prohibition on surface water discharge has been included in a number of versions of this. I don't know that we discussed it specifically, but if I were to guess why, it would be because if something goes wrong, a discharge to a surface water body might have a more immediate impact. And so having, a discharge permit for groundwater is potentially a safer first step. And I would argue that it should probably just be included in number 4 instead of 2 and 4.
Okay, let me just clarify this, Chair Thompson. So you are suggesting that no discharge be allowed to surface water of treated produced water, even from pilot projects?
Yes, Chair Thompson, Commissioner Zemlik, I would argue that because of the way the rule is written and part 4 sort of deviates from the previous 3, where it allows for, where there's some discussion of a discharge permit, which we then kind of expounded upon yesterday, saying that for pilot projects, it may be appropriate, that discharge to surface water remain in the prohibition, and that only part 4 discharge permits for pilot projects to groundwater be considered.
Okay, thank you.
And this is Commissioner Zemlik, I would again say this is a 5-year sunset. So potentially at the end of 5 years, these demonstration projects show that you could contemplate revising A2 of the rule.
This is Commissioner Fry. I think mainly I just want a clarification, but the change would be to the last paragraph, if I remember correctly. And so we're changing demonstration projects or industry projects to pilot projects, correct?
Yes.
And they specify following the determination of no discharge permit required issued by the department. So I'm just mulling over what Commissioner Zemlik was saying, that if there was an accidental discharge to surface water, the impact would be more
Immediate.
Did you word that? It would be more
Impactful.
impactful immediately versus groundwater would have less of an impact. And I'm not sure I see the difference, honestly. It would be more immediate, yes, on surface water, but I don't see that the impact would be any less.
Perhaps I'm just saying, contemplating, the stopgap measures for groundwater discharge permits, that it might be easier first step. And I don't know the inner workings of NMED, but I would guess the process of getting a surface water discharge permit is a very difficult thing to do. Just based on our hearings and permits that we've reviewed. So,
And you're dealing with Dallas for the time being, right?
And I'll just go back again to that last sentence that so pilot projects submitted to the department through the notice of intent process are authorized to operating following the determination of no discharge permit required. So did we make an additional change to allow permits of some kind?
Yes, my understanding was that we had added an exception at the end of that. And that was part of what I was hoping to get read back, was that, because I couldn't remember it specifically. Commissioner Laney, apologies.
This Chair Thompson, I appreciate Commissioner Zemlich's observation that a surface water discharge will have an immediate impact, whereas groundwater, there will be some delay. And I sort of look at it differently. I think if it has an immediate impact, then we want to do everything we can to prevent it by putting stringent permit criteria on it. So I would argue in favor of allowing permits to be issued for treated produce water to surface water.
Chair Thompson, I don't think I worded my argument very artfully, but just to sort of rewind the tape, I think, and focus on those questions, there's no standards for this now. And I think that the issuance of any permit discharge to ground or surface is a really heavy lift to do without standards, I think, as argued by the department, which is my understanding why the prohibitions were in place. And I think we carved out maybe a potential exception for larger scale demonstration projects that maybe weren't a nebulous big operation, so that, it could move the science forward. But again, there's no standard. So my concern is that we will put the department in a position of evaluating discharge permits without having the standards to do so for this source water.
Excuse me. So this is Chair Thompson, there are standards. We have surface water standards for all, however many stream segments there are in the state. There are surface water standards in the regs. I can never remember. It's 20.6.4.2, but there are standards, stream standards, and an NPDES permit would be written to assure that there is no exceedance of those water quality standards.
Yes, Chair Thompson, I understand that, but I think the arguments that we heard in their testimony is that if it was an easy transition from the standards we have now to this source water and applying standards, we would be there. But as Commissioner Fry mentioned yesterday, drinking water and drinking water sources, we understand more. And I'm just concerned that they will be confronted with a bunch of applications because of this that they clearly haven't developed standards for yet, or may not for some years. Thank you.
Chair Thompson, Mayor.
Commissioner Harms.
Thank you. This is Commissioner Harms. I think with the passage of SB 21 and signing by the governor yesterday, this may be a little more complicated when we're talking about protection of surface water, because the NIPD's permit, sorry, NP, I always call it NIPD's, so I'm reverting back to my lingo here, but the National Pollutant Discharge Elimination System permit is a federal program that the state will administer to protect waters of the United States. SB 21 will protect waters of the state. And it's going to take some time, as you said, to implement those. And I think in this area of transition, I'm more comfortable with Commissioner Zemlich when it's best, since we have a 5-year sunset on this, in the meantime, while that is getting worked out, to prohibit the discharge to surface water.
Chair Thompson,
Yes.
this is Commissioner Fry. So in section 4, if I'm reading this correctly, they essentially are, the department shall not issue a discharge permit or a a permit modification that includes the discharge of treated produced water without development of the standards. I'm not sure why that would stop pilot studies that through the NOI process or any other process would prohibit discharge and would have the assurances that there will be no discharge. I don't see a problem with that. I am concerned that the notice of intent is a process that will guarantee that down the road, different administrators, different people in positions within M&D or in the state would be allowed to change that notice of intent, whether to disapprove it or allow it, or in some other way to change it. I'm wondering if there's another permit process that would not allow discharge, but would oversee the pilot projects that are approved.
Other comments? Commissioner Brankart.
Well, I've been hesitating to say anything because I've struggled from the beginning about why we're dealing with surface water issues and what are largely groundwater regulations here. And particularly since we are not a privacy state for surface water. So I guess I just don't see how we're going to do, somebody's going to apply for an MPDS permit for a pilot study to dump treated produced water into the Pecos River. I don't see how that's going to happen, and I don't see why we would allow it.
Commissioner Rankert, this is Commissioner Zemlich. I agree with you that wouldn't be allowed, but it was part of the expert testimony in this hearing that the reason for this, the importance for this was shortages and compact applications. So I think it's important to address it because that is part of what has been discussed in the record is, we have compact obligations, produce water, it's in the right location. It could be used to meet these shortages.
Well, I understand. And, for the record, I am 100% in favor of dumping as much produced water into the Pecos River just above the Texas state line as we can do. Texas is planning on turning Red Bluff Reservoir into the next Great Salt Lake, so we can contribute to that. But other than that, I don't think we should be generally allowing produced water into the surface waters of New Mexico. Unless through the development of our state surface water program, there comes a process for doing that. And, Texas is in the process of developing standards for putting treated produced water into surface waters. We can see how it goes.
I think this is Chair Thompson, I think we did receive testimony that Texas, within the last 2 years, has passed law or regulation, I don't recall which. I think it was before the legislature, so it was a law allowing discharge to surface waters. But that's not New Mexico. So
Chair Thompson.
wait,
Okay.
I'm sensing the commission is not in favor of allowing discharge of treated produced water to surface water. Is that correct?
And
So
Chair
we-
sorry.
So I'll make sure you get a chance. The question is, do we want to change any of the language in 400A Part 2?
And
Mr. Fry.
Commissioner Fry, I was going to say that I think we sound like we're satisfied with 2, that a lot of this discussion is around 4, so that we should go ahead and accept 2 as it is and move on.
Okay. Any further discussion on 2? All right, let's move on to 3. So we're now 20.6.8.400 A3, untreated produce water discharge to groundwater. And the proposed language proposed by the department says no person shall be allowed to discharge untreated produce water to ground. I assume that y'all are in agreement with that. Do you want to change the language? I'm seeing heads shake, so we'll let the language as proposed by the department stand. Now we go to 20 points, well, part 4. So it's 400A4, which is treated produced water discharge to groundwater. Commissioners?
Chair Thompson, Commissioner Zemlich, I think Commissioner Brankert had the language that we agreed upon yesterday for this.
Commissioner Laney?
Agreed. I was just hoping that we could have that read back in its entirety. I would just like to hear what we did yesterday to remind myself of the actions that we took. Thank you.
Commissioner Brankert?
Okay. And frankly, I think we're going to need to do some further work on A4 following up on this, because all I provided was at the beginning of A4, the phrase except as provided in subsection B of section 400. Whether that needs to apply to the second sentence also, because the second sentence is the actual prohibition on a discharge permit. Guess we could turn the first and second sentences into one long sentence, just put an and in there.
Commissioner Thompson. Commissioner Zemlich, I would also pose that the modification suggested by Amigos Bravos and Sierra Club of removing the last two sentences without development and adoption of standards specific to treated produced water demonstration projects or industrial projects submitted to the department through the notice of intent in subsection C, and MAC blah, 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 were authorized to operate following the determination of no discharge permit required. And I would suggest that on the basis of demonstration projects is no longer a term. We're not allowing industrial projects.
I got rid of it
And there are no standards.
with whoever you didn't know who was trying to join, but that was it.
I mean, for the last 50 minutes or so.
Let me just understand. The proposal is that we will include a phrase at the beginning of part 4 that says, except as provided in section 400.b. And then it will read as written.
That's
And
good.
Commissioner Zemlich has proposed eliminating the last, actually the last 4 lines, which was suggested by Amigos Bravos Sierra Club. Is that clear?
It's 5 lines, but yes.
On my, on,
C4.
yeah, it's sort of 4.5. Okay. All right. We're in agreement? I'm seeing heads nod.
So no, now I'm sorry, I'm confused. I thought yesterday that Commissioner Brankert's motion went beyond except as provided in 400B. And this may be the language you had in mind, Commissioner Leahy. I think I found it. Pilot projects that involve treated produced water may obtain a discharge permit as determined by the department. I'm having trouble reading my notes, but wasn't that part of your motion, Commissioner Brinker?
That's correct, but that language I proposed to go at the beginning of 400B.
Oh, okay. So that's, I think
Yeah.
that's the confusion. All right. Thank you very much.
Everybody clear? Ready to move on? I'm seeing heads nod. So now we go to 400B, which is authorized uses. This is where we have reference to pilot projects.
Mr. Chairman, I guess I would just call it authorized pilot projects. Uses has a specific meaning under Produced Water Act, so I would kind of avoid using use.
And with what we just, this is Commissioner Fry, with what we decided yesterday, that first 5 words in B, we are changing to pilot projects anyway, so that makes sense to me to make that change.
I think that's a good suggestion.
So the suggestion is to change the title of this section, sorry, this is Commissioner Laney, to authorized pilot projects. Is it the intent that later this would be added to include authorized uses? So will we create confusion, or would we just edit that later when the rule is further expanded? And I guess, is the department authorizing pilot projects? I know the notice of intent walks through what's required there, but is the word authorized appropriate? That's my question to that.
Mr. Commissioner Branca, I believe the intent of the whole discussion yesterday was to allow pilot projects either under an approved discharge plan, or if it's not gonna, there's a determination that it's not needing a discharge plan, it can go forward.
I agree with Chair Thompson. And the other thing is, remember, two things. One, there's a sunset clause, and hopefully the Environment Department is going to come back much sooner than 5 years, 5.5 years from now with specific criteria that will allow
Uses.
other uses, yes. That's directed under the Produce Water Act. Okay, so I'm looking at 400B. We're going to change it to authorized pilot projects. And then in that first paragraph, everywhere where it says demonstration projects or industrial projects, we'll change that language to pilot projects. Is everyone comfortable with that? Okay. I'm seeing heads nod. So now we go to 400B1.
Mr. Chair, my motion creates sort of a very awkward sentence there. So hopefully we can clean it up or somebody else can clean it up later, that first sentence in 400B.
Okay. Do you want to clean it up now, Commissioner Brankart?
Yeah, I think I started phrasing it as pilot projects may be allowed under a discharge permit, or, and then just delete all those other words, if determined by the department not to require a discharge permit, because the pilot project will not discharge in the manner that it may. And then instead of saying are subject, say will be subject to the following requirements. How's that? It's long, it's awkward, but I wasn't an English major.
I just have one, is it going to be will or shall?
Shall, there you go.
This is Commissioner Fry. Do we need council's weigh in on that? Well, he said it was, I thought he said it was specific to this situation.
Yes, but he also implied that shall has a greater force behind it. And I think that in this case, we want to press that.
Yeah, good comment.
Just my interpretation.
Shall.
Okay. It's 10:30. Let's take a 15-minute break. We'll reconvene at 10:45. Demonstration projects, we change that second. I don't think it's now. Authorized pilot construction. And I think we can First, say, the change definition project to other projects. And so now B1. Is that correct? This is the church project on Western. Yeah, we changed that. Versus expecting that. And apply with all that with the council and vote and need some decision meetings. Including. That's. And these satisfy. Look at that. Okay, we're back. We had some audio problems. So Commissioner Fry has suggested we revisit the first sentence or the description under section 400B. And would you read it again, Commissioner Fry?
The suggestion was from Namoga to strike part of that first sentence. Demonstration project, or rather it would be pilot projects per our changes determined by the department not to require a discharge permit are subject to the following requirements. That is removing, because the demonstration project or industrial project will not discharge in a manner that may directly or indirectly affect ground or surface water, which seems like that is included in the discharge permit process.
Okay, this is Commissioner Thompson. Does everybody understand the suggested change? That is simple and concise, I agree.
And so, Chair Thompson, Commissioner Zemlich, does this mean that through the NOI process, if one of these pilot projects is able to obtain a discharge permit, that it's covered under this and it also covers the ones that don't? Yeah.
Okay. Okay, let's go back now to 400B number 2, which is it would state, demonstration project shall be designed, the pilot project shall be designed to provide information specific to untreated produce water quality, treatment technologies, treated produce water quality, treatment volumes, and toxicity studies for potential produce water reuse applications. This seems pretty straightforward to me. Any thoughts?
Yeah, doesn't look like there's any substantive changes suggested by
Pretty
it.
straightforward. And you're right. Parties offered substantive changes. Okay, we go to 400B3.
Mr. Chair.
Mr. Brankard,
Um, I think this is really awkward. And plus it's referring, 1201 is the process in the groundwater regs for notices of intent. We're sort of creating a whole new notice of intent process here. So that it's, I don't know why you would refer back to that process. So I would delete that first phrase. And then, again, I don't know why we have the unrelated to oil production of oil and gas. Perhaps it should read any person intending to conduct a pilot project and then go jump to shall submit to the Groundwater Quality Bureau of the Department a produced water notice of intent prior to use.
that's simple and succinct. Okay, questions, comments? Agreed?
Yes.
I'm seeing heads nod. So now we go to 400B4, which refers to demonstration projects, but we're going to change that to pilot projects, shall not commence until the department has made a determination of no permit required on the notice of intent. Commissioner Brankard.
Mr. Chairman, since that we are now allowing a discharge permit, I would think it should read pilot projects shall not commence until the department has approved a discharge permit or made a determination of no permit required.
Okay. Let me state what I think I heard. You said shall the pilot project shall not commence until the department has issued a discharge permit, has approved a discharge. Should it be approved or issued? That was my issue, my question. Should it be approved a discharge permit or issued a discharge permit? I don't know. Is there a time difference between when it's approved and when it actually takes effect?
This is Commissioner Brecker. I think you may be right. Issue might be the better word. This is an actual permit.
Yeah.
Not just stamping approval on an application.
This is Commissioner Fry. In A4, we did change, or we accepted the change made by NMED to say the department shall not issue instead of approve.
Okay. So we're going to accept Commissioner Brankard's suggestion. Right?
I'm sorry, can you restate that, Commissioner Laney? Sorry, can you restate that one more time? I just want to make sure I understand.
Pilot projects shall not commence until the department has issued a discharge permit or made a determination of no permit required on the notice of intent.
Okay, everybody? Let's move on to number 5. This will be 400, Part B, Part 5, Subpart 5. Refers to written procedures describe.
Commissioner Laney. I just have a question. So it states the person transporting, storing, treating, or utilizing. We've had other similar strings regarding the movement, and it included distribution. Do we need to include that here to be consistent? I would think so.
I'm saying heads not, so
Yep.
we'll include distribution. Okay, we'll move on to 400B, subpart 6. It says all untreated and treated produced water will be handled, transported, and stored in accordance with other applicable local, state, and federal regulations. And I would suggest we include distribution. Anybody have concerns with that one? Okay, let's go to, excuse me. I got choked up. 400B, subpart 7. Deals with the release of untreated or treated produced water. This one raises an interesting question. Right now, I assume that transport of produced water is governed by OCD regulations, whether it's piped or trucked. But here it seems to imply that maybe some of this is under the jurisdiction of the Produce Water Act, under jurisdiction of NMED. Is that a correct interpretation? And if so, is that a conflict? Commissioner Laney.
Yes, I don't see a conflict because they are including except released under authorities of, and then they go on to further elaborate those authorities.
Okay.
I have a question.
Yes, ma'am.
Thank you, Chair Thompson, and maybe Commissioner Brankard can answer this. I believe the Oil Conservation Commission or Conservation Division, if there are releases, there are financial consequences. Are those built into this at all? I mean, i.e., example, if you have a spill and there's some ambiguity about how you were transporting it, it would seem beneficial to have the reason be the one that doesn't have a cost associated with it. So, is that something to consider?
Well, Mr. Commissioner Brack, I think the Produced Water Act divides the line, okay? And so between the jurisdiction, I don't think we can move it one way or the other. You know, if you spill something under the authority of the Conservation Commission, it is a violation of the law now. And there are penalties for just simply spilling. Plus, there's a very detailed release cleanup needed. Whereas under our rules, we have a very sparse rule for cleanups, which I think with the passage of Senate Bill 21, we will be forced to change because I think it goes into more detail about cleanups. But that's just sort of the way it happens. And, you know, I think this is fine. I mean, it's a little wordy, but um, basically, if there's a spill, the agencies get, and there's a question, the agencies get together and figure out who's responsible and who issues the NOV or the compliance order, or if necessary, or whose rules apply.
Thank you, Commissioner Brinkert. Just to add to that, I think because of the rules that OCD has developed over time, there's also rules about transporters and certifications. And from my end of freshwater haulers, there's, issues there. And just to throw it out there that not having a distinction between those types of transporters may risk the chance that some transporters might do both.
This is Commissioner Barker. This is sort of an issue I brought up earlier, which I think that if the Environment Department wants to have more detailed allowances of using of treated produced water outside of the oil and gas field, they will have to regulate how it gets transported, whether it's pipelines or trucks. I mean, it's not just discharges they have to regulate. They have to regulate the whole process of when that produced water moves through the system from treatment to use and disposal.
Yes. Okay, getting back to 400B7. Any suggested changes? Okay, hearing none, are we ready to move on to 400B8? Again, the one change we'll make here is instead of referring to demonstration projects, we'll refer to pilot projects.
Mr. Chairman?
Commissioner Brancard.
Yes. I have heartburn about this section, although most of my heartburn is relieved by the last sentence. I mean, once this produced water moves into the jurisdiction of the Environment Department for a project off the oil field, I don't know that you can take it back into the Oil Conservation Commission's jurisdiction for disposal. But the Environment Department has control over other kinds of disposal authorities. I mean, an example, again, I bring it up, is that, oil field waste is generally injected through a Class 2 well. But if you're at a refinery, that waste somehow gets transformed and it has to be injected in a Class 1 well under the water quality rules. So that may be what happens here, that you have to inject this. If you have liquid waste left, you may have to inject it in a Class 1 well rather than a Class 2 well. But, I see that under the alternative provisions of the last sentence here. I think the Environment Department needs to have a discussion with the US EPA about what happens to the status of this waste. Because we're talking about Safe Drinking Water Act regulations when it comes to injection wells.
Yes. So this, Chair Thompson, if, for example, the water is treated, it will generate some residuals, waste salt. But if it's treated on site, it's still in possession by the generator. If it's treated off, and let me complete that sentence or that thought. It's treated by the generator. It's an oil and gas company. It remains in the possession of the oil and gas company, and they can dispose of that in a class 2 injection well. If they release it to a private company, not owned by the oil and gas, the industry that generated the waste, the ownership is transferred to the new company, and the residuals, the wastes, the sludges, the salts, and so forth, that would not be eligible for disposal in a class 2 injection well.
Commissioner Branco, okay. You know, in the oil field, it's often, the generator is usually not the one disposing of it. These companies, like we had testifying, Select Water Services, is what they call midstream companies. They're huge. They are the ones moving all this produced water around, okay? And they're often the ones taking it to a disposal well. If it's still oil field produced water, it goes to a class 2 disposal well under the WQCC rules, okay? My concern is that by somehow taking this water and putting it through process to test it for a use that is off oil field, that you somehow transformed this water from an oil field waste to, say, an industrial waste. And therefore, it would have to go to a class 1 disposal well rather than class 2. So the Environment Department really needs to sit down and talk to the US EPA about how that works. But I think the last sentence here sort of saves us because you're not stuck with having to do the oil field disposal.
I'm just going to offer one comment here. Reviewing the other parties' proposals, NEE and CGFCM did go on at length about the issue you're bringing up, which is that the disposal can be hazardous. And their suggestion was to send it all back to the oil field. I will note, though, that both Amigos Bravos, Sierra Club, and NMOGA had precisely one change to recommend in Section 8, which was to delete the word industrial project. So neither Amigos Bravos nor NMOGA suggested anything else around 8. And the fact that they might agree on that gives me hope, I guess, that it's workable for now.
Yeah, this Chair Thompson, you know, it's interesting. As long as the water is within the industry, and I guess midstream companies are considered to be part of the oil and gas industry, they enjoy or benefit from some exemptions. And once it leaves the industry, so again, if some commercial operator said, I want to take your water, I'm going to treat it, and I'm going to sell it to the city of Hobbs, they would now be subject to RCRA and possibly the Atomic Energy Act because of the technically enhanced naturally occurring radioactive material. I think we ought to leave it the way it is and encourage the Environment Department to have those conversations for the next iteration.
No, you're absolutely right about the hazardous waste issues. So, I mean, that's why our refineries in New Mexico are regulated by OCD under the Water Quality Act and the Hazardous Waste Bureau.
Okay. So it's been pointed out that there's no changes offered to 8, except for the substitution of pilot projects to demonstration projects. So is everybody comfortable with 8? I'm seeing heads nod. Let's go on to 9. And this sort of addresses that last issue that I brought up. Disposing of components of a pilot project. It's pretty straightforward. But again, it could be complicated if the water was released outside of the industry. Okay, any further thoughts about 400B9? Hearing none, let's move on. So next part is part C, the NOIs, notice of intent. Six. Okay, so the first sentence seems pretty straightforward to me.
Mr. Chair,
Commissioner Brancard,
would it be better to say any person intending to conduct a pilot project shall submit to the Groundwater Quality Bureau notices?
that's a good suggestion. Should we further clarify it to say intending to conduct a pilot project to treat produced water?
I have a question, Commissioner Laney.
Commissioner Laney?
We just changed authorized use to authorized pilot project. Would it not work to say any person intending to use produced water for an authorized pilot project under section B, et cetera? Would that not be appropriate?
I'm seeing heads nod. I think that's a very good catch. Thank you. So we're going to change authorized application to authorized pilot project. Is that correct?
Yes, so any person intending to use produced water for an authorized pilot project, because we had just renamed section B, authorized uses, to authorized pilot projects. That would be consistent with the language that we created or used.
Okay, let's go to C.1.a. We're starting to get into the information required in an NOI, a notice of intent. And so A says notices shall be on a form provided by the department and shall include the following information. I don't think there's anything uncertain about part A. Now we go through subpart I. So the name and address of the person intending to conduct the pilot project. Name and address seems pretty useful. Part B or subpart 2. So I mean, let me just clarify. 406.8 C, number 1, small a, subpart II. Okay, location of the intended project. Okay, we'll move on. Number 3, the concentration of water contaminants in the untreated produced water used in the pilot project. Comments? Okay,
May I make an observation, Mr. Chair? This is Felicia. Other than the changes you've already made around striking out the word industrial project and the more dramatic replacement for this section suggested by NEE and CGFCM, Amigos Bravos and Sierra, Namoga offered only, Amigos Bravos Sierra Club offered a new section at the bottom of that around documentation that property owners adjacent, have received notice. And that was really the only change proposed in A.
so I think you're suggesting we can just accept all the subparts in A1?
I'm just saying you don't
I-
have other proposals there.
Is everyone comfortable with that? I think there might be a little bit of editorial changes needed, but we can deal with that. Okay, so that was 400C, Roman numeral 1. We've accepted all of the language there. I'm sorry, not Roman numeral 1, Arabic numeral 1.
1 through 11, and then 12 is the additional one.
Correct.
Yes, thank you. I appreciate that. And that Roman numeral 12 suggests that the NOI include documentation that all property owners have been notified.
So Chair Thompson, are you asking us to say, yes, we approve of
1 through
1 through 11 and the addition of 12?
No,
You're just asking 1 through 11?
Yeah.
Okay, I'm fine with that.
okay. And now let's consider 12.
12 is on page 38.
Yes.
And this is Commissioner Harms on part 12. I'm in support of the addition because I think building in extra communication on the notice of intent process is a good idea in general, especially surrounding this new science.
I agree. Commissioner Brinkhart.
Mr. Chair, the question I brought up during the hearing when this issue came up was so NMSU or UNM decides to have a project, are they going to notify every property owner surrounding the whole campus?
Good question.
And everybody would sort of look to me strangely. And
So with our changes, I'm sorry, Commissioner Lady, it would be only pilot projects, right? So the big scale projects that the university is more likely to carry out would not require notification. Is that correct in my interpretation?
That's what you did yesterday. This is Felicia.
So then if the university were to carry out a pilot project, because the university does have lands that are associated with it, then they would have to notify in that situation. Is that kind of what you're getting at? Or have I misinterpreted that?
no, I agree. I think that that eliminating the bench scale helps, but I still wonder whether there would be small pilot projects on a campus, et cetera. Greenhouse style projects.
I can't imagine anything other than bench scale project at the university. I'm sorry.
In the next,
Sorry?
sorry, I would just add in the next 5 years is what we're talking about too.
The other thing is that it says property owners adjacent to. So we don't have to notify everybody within a 5-mile radius or something like that. And all pilot projects that were described in the exhibits were at very remote locations.
I would argue that there are pilot projects, this is Commissioner Fry, on university land. And therefore that would need to be considered in this.
Commissioner Fry, Commissioner Zemlik, I wonder if there's options for public notice, like a newspaper advertisement as an option, which sometimes people don't like to do, but maybe it's an option for universities to just sort of check those boxes and let the public know what they're doing. I had another thought, I just lost it. There's something associated with that, but I mean, oftentimes the public notice, oh yes, my second point was within this rule, the public doesn't really have recourse to protest or to stop a project. So this is, I think notification is important because they don't have the ability to, intervene. And so consistent with how other agencies advertise, it would seem some sort of newspaper advertisement might also suffice in some circumstances.
Okay, as written, Commissioner Zemlik, this is Felicia. It says receive actual notice. I would say that would mean maybe certified letters, but certainly correspondence. You would have to change that to allow for newspaper notice, which I will say, just based on doing public hearings for a long time, most folks don't think that classified ad really is very effective for the general public.
Certified letters are cheaper.
Is that what is meant by the language? I mean, I'm curious because, as an email to your neighbor, if you go post the notice on their door, in their mailbox, I don't know about these things. Would that suffice in this language?
So actual notice, I'm not sure whether what they were contemplating there were certified letters or simply letters. But it would be something other than a posted notice at the post office, something other than a classified ad.
In addition, as hearing examiner, the additional language provided in the section 4 talks about notice on the website as well. Just to offer that as, I think the intent is to cover a lot of informational bases because the public has really demonstrated that they're concerned about this. But like Commissioner Fry mentioned, if a university is doing something like this, I don't know how many adjacent properties there are to New Mexico Tech, but I would assume it's a lot. But I don't know.
Perhaps a more foundational question would be if in fact the university is conducting an actual pilot project, which can be up to, you decided yesterday, 2,000 barrels a day, 80,000 gallons, right? And it's not a bench scale project, which you've already exempted. And what is the objection to providing notice to the neighbors?
Yeah.
And I'll just couch my comment. I'm speaking generally about pilot projects, not specifically about produced water projects. I don't know of any universities that would do that. I have to agree with that. But I do know, I think there are projects ongoing on university campuses in New Mexico that are doing pilot projects of some kind.
Mr. Chair, this notice only applies to a notice of intent, okay? If the department determines that this project is of such a scale to require a discharge permit, then there are all sorts of public notice requirements for that discharge permit. So I'm wondering whether, I mean, the more impactful projects may require a discharge permit and therefore trigger lots of other lots of other public notice. So do we need 12 if we just have 4? And again, these are not the petitioner's proposals. These are proposals from members of the public.
Chair Thompson.
Commissioner Zemlik.
To Commissioner Brankert's comments, I think the concern from some of the previous NOIs that we looked at were in pretty remote locations. And, there's the spectrum of a university campus with hundreds of neighbors to a remote location that may have a couple and may not be captured with the website. Which is why I was sort of suggesting maybe there's a in the notification process, if there's an approach that suits the purpose, so that in cases like those, that the neighbors would be directly notified, but that might not be necessary if it's nested in a university campus and it doesn't have a discharge permit. But I like the additional notice for neighbors because I do think there is a concern that these studies, like some of the ones that have been conducted, will up in their backyard.
I like the language. I support it. I think notice is important. And if it's a university campus, which I'm extremely doubtful, but it could happen, I think notice would be appropriate. So what's the sense of the committee? We want to accept the language offered by Amigos Bravo Sierra Club?
Yeah.
Okay, I'm seeing that. Okay, let's move on to B. I've sort of lost track. We're 400, section C. Part 1, small b, lowercase b. The department at its discretion may request additional information. That seems pretty straightforward. Everybody agree? Subpart D, is there no subpart C? Yeah, I think that should be subpart C. I think the number got, the letter C got lost.
Sorry.
Subpart lowercase c says, based on the information provided, department shall make a determination if a DP is discharge project as the discharge permit is required. I'm sorry, I misspoke. it shall make a determination if the pilot project meets the requirements in this section. In other words, if the information provided in the notice of intent is sufficient. And again, I'm comfortable with that. Any comments about subpart lowercase c? Commissioner Brancard?
Well, Mr. Chair, I think this is the point where the department will determine whether somebody needs a discharge permit. So I think we just need to say that rather than that last sentence, which the last sentence sort of assumes that if you need a discharge permit, you go away. I think maybe we should just need a sentence that says, the department shall inform the applicant if a discharge permit is required.
Okay, is that clear? So Commissioner Brancard, I think is suggesting that we include a statement in this section that the department shall make a determination if a discharge permit is required and notify the applicant. So, okay. Okay, let's move on. So now we're at 400, part C, number 2.
On page 36.
Yes.
I'm looking at one of the NEMOGA changes. It's small, but I like it. It's to put a title of data reporting requirements on that section.
Can find that on page 41.
Thank you. And this is Commissioner Fry again, and then they go on to add a B and C to that section. So the first paragraph is A, then they add B and C. B is persons implementing industrial projects pursuant to blah, blah, shall submit to the department monthly reports with treated produced water quality data as requested by the department. And then C, the data reporting requirements shall not apply to I don't know if that one's needed, but to pilot projects fully within oil and gas operations, not subject to department regulations.
This is Felicia. Commissioner Fry, I believe B has been, proposed B there from DeMoga has been mooted because pilot projects would be in A. And you have already decided not to include industrial projects for potential approval.
Sorry, yes. So I think it might be useful to change that pilot projects and then keep that. Is that what you're getting at? That B would be removed if we were leaving it as industrial projects. But if we were to change that to pilot projects, that is.
But aren't pilot projects addressed by A?
It's vaguely addressed in terms of their plans for reporting. I would agree with Commissioner Fry that a monthly reporting would help to avoid some of the issues that have happened in the past with NOI projects where it's like, wait until the end and then maybe you get something, maybe you don't.
Yes, because I believe A is only, sorry, Commissioner Fry again, only referring to a final report.
Okay. Sorry.
So I would propose to add the title, add B for pilot projects, except A for pilot projects. And then I'm on the fence about C. I'm not sure that's needed.
This is Commissioner Zemlik. I agree that's within the oil conservation division's purview, so we wouldn't, any recycling in the industry wouldn't have any bearing on this commission. I think should exclude it.
I agree. Okay, my mind was wandering. Um, Commissioner Fry, could you restate what your proposal is?
I would propose accepting Namoga's suggestion of adding a title to that section 2, or whatever you call that, number 2, data reporting requirements. I would accept the first paragraph becoming A for pilot projects, removing demonstration projects or industrial projects, and accepting Namoga's suggestion of a paragraph B, submitting to the department monthly reports with treated produced water quality data as requested by the department.
And then subpart C would not.
I don't know that we need it, yeah.
Just to make sure I understand, include B, strike industrial projects, insert pilot projects. So the ask would be that a person carrying out a pilot project would report to the department monthly regarding the produced water quality data.
Yes, this is Commissioner Fry. Thank you for that clarification. That is what I intended.
This is Commissioner Zemlik, may I propose a small amendment, is that it refers to produced, that additional section B, monthly reports with treated produced water quality data as requested by the department. Would it be better to just request general water quality data because it's the influent, it's the waste stream, it's the concentrate and the treated produced water? And whatever else.
Yeah, this is Commissioner Fry. I agree that's a good change.
Yeah. So perhaps it would say monthly reports with water quality data for all liquid streams.
I would continue though with as requested by the department. I like having that extra. Yeah, control, whatever.
Yes. Okay. So is it clear what Commissioner Fry is suggesting? So we have a 2, which would be data reporting requirements. There'd be a part A, there'd be a part B, and we would not have part C. All right, everybody in agreement?
At this point, Amigos Bravos and Sierra Club have a proposed part 3. Which can be found on page 38 near the bottom.
Yes.
This is Commissioner Zemlik. I like that addition. I might make a suggestion here that the 3 sections be rearranged a little bit. So as it reads, the department shall publish on its website all applications for produced water notices of intent, supplemental information provided by the applicant at the department's request, all written information, all written procedures and plans required by paragraphs B and C in the section, and the department's determination. I think all written procedures, all of the things that were filed with the notice of intent should be available, as well as the department's determination, and then supplemental information provided by the applicant at the department's request, which could occur different times, be included as the last point.
Sorry, would you read the exact language you propose to insert?
Yes, thank you. So the.
And I'm sorry, where you would put that also?
Okay, so this is this section 3 now in ours? Okay, so for section 3, I propose the language, the department shall publish on its website all applications for produced water notices of intent, all written procedures and plans required by paragraphs B and C of this section, the department's determination, and supplemental information provided by the applicant at the department's request. Am I understanding that correctly? That's how I like visualize it happening. Yeah.
Mr. Breckard.
Commissioner, Mr. Chairman, and I guess I'm addressing this to Commissioner Harms too. This provision only deals with notices of intent. I believe the department has all information about discharge permits on its website. So we wouldn't need to have a requirement for discharge permits, right? I think the department has all the information about discharge permits already on its website.
This is Commissioner Harms. I believe that is true. I'd have to check it though right now to see. That's my understanding of it.
So, Commissioner Brinkert, if I might, I only am familiar with the discharge permits for the, that relate to hearings I do for them. And those are the ones that are of substantial public interest. And certainly for the ones of substantial public interest, everything is on the web page because it's part of the record, on which we're doing the hearing. But I can't answer the question. It's the ones that are not of substantial public interest.
I think that's a good language. So we're going to add section 3, which is listed as section 4 on page 38 in the submittal by Amigos Bravo Sierra Club. All right.
I got it.
Super. So where do we stand? Is that the end?
No, sir. We jump to page 41. CM and NEE. So NMED and the others did not have a section D. But CGFCM and NEE proposed new sections D and E. And you find that on page, starting at the bottom of page 41, continuing through 42, 43, and on to 44. And then the basis for that proposal is set out in italics on page 44. And then you're done.
Yes, I remember reading this.
Chair Thompson, Madam Hearing Officer, on page 44, the two paragraphs that are in italics, is that from your advisement, or where do those come from?
Oh, Commissioner Fry, I have made no recommendations in the report. What's in italics is what was expressed in the post-hearing submittal by the proponents of these new sections D and E, namely NEE and CFG FCM.
Okay, thank you.
Chair Thompson, Commissioner Lady, from my understanding of this proposed section, it is specifically dealing with big scale sized projects that are utilizing produced water. And it seems like, based off of everything else that we've done in this would require a whole new element that we're not seeking the big scale size have the same specific requirements as, say, a pilot project.
Yes.
So I don't know that I support this additional language, but there may be some merit other commissioners could bring forward.
Chair Thompson, can I do a follow-up? So you're saying on their section 1 under D, correct? You're not talking about the following
Right.
2 through whatever?
No. Yes, thank you. Yes, specifically what they I just started at the beginning, what they pointed out here in section D1, those are specifically provisions for big scale research sized projects.
Yes. Commissioner Brancard.
Mr. Chair, while, if we spend the time, we may decide this is a brilliant rewrite of the Environment Department's proposal for notices of intent. This isn't really the proposal that went to hearing. We went to hearing on the department's proposal. And so while this is a great idea submitted at the end by one of the parties, maybe the Environment Department can take it under consideration for the next round.
I'm seeing Ed's nod. I agree. And for the record, I strongly object to having any state regulations that provide jurisdiction over bench scale testing, laboratory scale testing. It's just not appropriate. Okay, so we've agreed that we're not going to consider the proposed sections D and E. All right, I think we're at the end.
This is Commissioner Fry. I have an idea for an addition, and I don't know quite where it would go, but I think it was Commissioner Zemlich said this yesterday, that there may be some bench scale projects that have some valuable data. And I'm wondering if there's a way to, I don't know, add a sentence somewhere inviting researchers with bench scale projects to submit data to the NMED. I just don't know if that fits within this, but it's just something I'm thinking about.
My thoughts are, this is a regulation. And if somebody wants to submit something voluntarily, fine, but I don't think a regulation is an appropriate format for inviting voluntary submittal of information or things like that. Okay.
This is Commissioner Fry, and I am satisfied with that answer.
It's 12 o'clock. Commissioner Fry has to leave.
I actually can stay till 12:30 if we wanted to.
What I'd like to do now is just open it up for a short discussion and see if there's something that we missed, something in the regs that that after 12 hours of consideration, we overlooked or would like to change. Commissioner Fry.
So I keep going back to this thought of with these rules, with the addition and the direction on the NOI process, does that stand regardless of any administrative changes? And I say that because the permit process is very well documented. If I'm correct in stating this in the rule of law, does the NOI process carry the weight of that?
I don't know if Commission Counsel wants to weigh in or not. I will say generally in administrative law, to the extent you have different regulatory provisions, we are directed by the legislature and the courts to do our best to read them in harmony. But Commission Counsel may have something to add.
Hi, this is Commission Counsel. I'm sorry, I missed the question.
Mr. Fry?
I've got to think how to say it again. With this rule and the passage of this rule, we are passing a bunch of instructions about notice of intent. And I'm just wanting to confirm that it will carry the weight of, if instead we went the permit route, would the NOI carry the weight that it cannot see changes in administration trying to change, I don't know, the process or something like that?
I'm sorry, I heard you the first time and I still don't, I'm not clear on your question.
Commissioners? I'm sorry, I may be misunderstanding your question, but since this would be in rule, the nature of the NOI as it's written, it couldn't be manipulated by a change of political power. They would have to go through the formal rulemaking process in order to make that change. But I'm not sure that I've interpreted your question correctly, so that may not be helpful to what you're asking. That's what I heard, and I'm unsure if that was specifically what the question was.
You interpreted it correctly, and this is just something that has gone through my mind since the beginning of the hearings and, since the changes from allowing permits to not allowing permits. Does the NOI carry the weight of a permit?
I would defer to the agency on that.
I'm sorry, now I understand your question less well at this point. I'm sorry. The NOI process is set out, the discharge permit process is set out. The agency is going to have to come up with a sensible way of implementing everything in a harmonious way, if you know what I mean. And as Commissioner Laney said, any changes to the rule you're adopting today are going to have to go through a wonderful lengthy rulemaking again. But Commissioner Brankard perhaps had something to say.
Yeah, I think the sort of underlying issue that's been around for a while is now that we're approving both the option of a discharge permit or an NOI that doesn't require a discharge permit. You have a discharge permit, there are conditions in the permits, an actual permit. You violate those conditions, you're subject to enforcement actions. I think the issue that's sort of been hanging around is, well, if we have an NOI that has all sorts of plans about how you're going to do this, and then you don't comply with those plans that you've submitted, what are the consequences? And is the department have the ability to enforce essentially the NOI?
What was interesting was the chair asked me that question, I think, the first day of the hearing, or the deliberations. And I think the department's enforcement authority is set out in statute and rule to pursue enforcement actions. It would be a compliance order that at this point would come to the commission on an appeal. And yeah, if it were issued.
Okay, so
Sorry,
again,
one more comment from Commissioner Fry, if I may, Chair Thompson.
yes,
So I just, at some point in this document, and we removed it, there was a reference to the Administrative Code 20.6.2.1201, which I looked at, and that's notice of intent to discharge. And that from having it been referred to in here, and I'm sorry, I don't remember where or who, I took a look at it, and I don't feel like it really applies very well to this notice of intent process. And I would just even venture to say, you know, would it be useful to go further and just rename the process something else? I'll just put that out there because I don't know.
Chair Thompson, Commissioner Fry, I agree. I think a number of agencies have NOI processes. And I think as Commissioner Brankard sort of clarified, this is a new process pursuant to the Produce Water Act and this rule. And I think it would be helpful to name it something for what it is. Notice of intent to
conduct a study.
Conduct a pilot scale. That's what it is, to conduct a pilot scale. So produce water treatment.
Something like the notice of intent to conduct an authorized pilot project, using the language of the rule to support that. I see what you're saying there.
Thank you.
I think that would satisfy me.
Yeah, me too. So I don't think it's needed, but I'm willing to go along without making it too long. What do we want to call it? Notice of intent to conduct a pilot test?
Authorized.
So my suggestion was just to make sure that I understood what was being suggested. I don't know that it's necessary either because it lives in this rule. And so to me, it's clear enough that within the context of this rule, these are the procedures for the notice of intent. But to that end, I understood what you were you were trying to say, and that you want to make sure that it's established differently or separately from other areas where there's notice of intent. I don't know that it's necessary, though.
And perhaps this Commissioner Zemlich, perhaps it's not a title issue, but in C1, submit to the Groundwater Quality Bureau Department a produced water notice of intent prior to use, and that the potentially produced water notice of intent at this point. That's the only kind of intent you can have with produced water is under this rule with NMED. Is that right? You can't use it outside of this rule, so.
That's kind of understand it. This is Commissioner Lady. I understand the confusion because what you're saying is separate from this rule, the surface groundwater has requirements not related to this for notice of intent. And the notice of intent here and the notice of intent elsewhere are not the same.
Yes, and maybe cause for confusion and concern.
Mr. Chairman?
Mr. Bayless.
Thank you. How about going to the definition section and then say that under this regulation, notice intent means what we want it to mean. A notice of intent to authorize a pilot project.
I think it's defined as
Thoughts?
Commissioner Zemlich.
and it's just a suggestion. It may be something that the department can just resolve internally and titling these things as they go out. Well,
Actually, it may already be resolved because in order to file, they have to do it on a document provided by the department. Is that not correct? So that document would likely include a scope for which this would live. Is that how it, I'm speculating. I do not know. So I'm asking.
does it exist yet?
I mean, I think it just says notice of intent. It doesn't clarify or specify. Sorry, this is Commissioner Harms. I don't have strong feelings either way. If it helps clarify things, I don't have a problem with it. I don't think it's necessary, but I think if it would be helpful to explain, I'm okay with additional language. I think that's reasonable.
Someone I think mentioned this, and I just want to return to this. So it's under notice of intent, part C, number 1, it says, shall submit to the Groundwater Quality Bureau of the Department a produced water notice of intent prior to use. So, I mean, that helps me. Could C be changed, the title be changed to produced water notice of intent? I think that makes it pretty specific then.
This is Commissioner Lady. I'm beginning to come around to thinking that it would be unnecessary. But what I would suggest is that the commission make a recommendation to NMED to title their notice of intents so that when they're received, they know that they're specifically for either groundwater or produced water. That would be my suggestion. I don't know that it has to be codified to the degree that we're suggesting here, but that's just my opinion.
Thank you, and this is Commissioner Zemlich, and the reason I'm not wedded to this, but I think it's maybe important is because I'm not going to put a percentage on it, but it was a very high percentage of the public that contributed to this hearing had a lot of concerns. And the idea that NOIs could get missed would be of, I think is of concern to them. And so whether that is the department explicitly labeling them that way, or if it's in the rule, I wanted to bring it up for the record because it came up over and over again.
Chairman, this is Commissioner Brecker. I kind of like Commissioner's suggestion just because the phrase produced water notice of intent pops up several times. And if we rephrase it, we'll have to change it everywhere. But titling this produced water notice of intent on C might be a good idea.
I'm seeing heads nod, so we're gonna title, geez, where am I? 400 point C. And then we'll have a title, a produced water notice of intent. Okay. And again, do you have something to add?
I was only going to refresh your memory on what the kind of ultimate motion needs to be.
Yes.
Okay, so someone would move and second, and then you would vote on a motion to adopt the rulemaking petition as presented with the edits and adjustments you've made throughout your deliberations, that they direct that the chair has the authority to sign the rule transmittal language, and that the Bureau has the authority to work with the Record Center in order to file the final rule in a format acceptable to the Record Center, and that you all expect a statement of reasons to be brought back at your next meeting that you'll agree to adopt in support of your decision. And I would work on drafting that with Commission Council's review.
Okay, so.
Mr. Chairman, can I make an alternative proposal?
Before we, not just yet. Before we go to making motions, I would like to, again, have just get reassurance that everyone is comfortable with what we've done over these last 2 days. So if anybody has any heartburn about anything, now's your chance to express that. And I will say I'm very pleased with the way it's our deliberations have been very collegial and moving forward rather than trying to criticize. My one bit of reluctance is, as we've continued this discussion, I'm reluctant about the expiration date, December 31st, 2030. 5.5 years. It seems to me 3.5 years might be more appropriate. And I don't know if what the other commissioners think, but there is a lot of information that was presented in the exhibits, in the testimony. I think there's certainly plenty of information to justify pilot testing. Maybe not approval of full-scale prototype plants, but so that's my one observation. Commissioner Zemlich.
Chair Thompson, Commissioner Zemlich, my 2 cents is that the department could bring forth additional rulemaking amendments to the rule next week. And I think the parties in this also have the ability to propose that as well. And I think that the 5 years, so erring on the side of departmental resources, it seems like longer is better rather than to kind of force them into a shorter time frame. But all the parties could get together and come up with something next year, which was suggested by some of them under this, and then the sunset date would just go away. My concern is that the sunset date would get rolled over and over generally.
Thank you. Commissioner Laney?
Yes, Commissioner Laney, I would agree with Commissioner Zimlick on this. I think that that's hedging on the side of caution for the department's sake. And there is nothing that would stop them or preclude them from moving forward in a shorter time frame. So I agree with what you've said.
Your thoughts? Okay, so looks like we're going to leave it at 5.5 years. Are there other concerns? So I think the biggest one is that we are allowing pilot demonstration projects up to 2,000 barrels a day. Okay, any concerns, Commissioner Brancard?
I don't know if I have a concern with the number. I do think, though, that it's a good idea for this commission to limit the size, which the initial petition did not. I think that's important. And we have a limited duration either, which is another idea. I think Texas does that. But, I would just sort of want to alter at this point, want to offer an alternative to this entire process. I researched how the Oil Conservation Commission is handling pilot projects for produced water, and they adopted a regulation 5 years ago. Here's what it says. Research using produced water is to be encouraged through pilot projects approved by the division. Period. So we've done a lot more than that. And I think we should be proud. I would like, though, the opportunity for the commission to review the proposed changes before we bless it and send it off. So at the next meeting, not only have a statement of reasons, but the act, all the little changes. So before we say, yes, this is what we're approving, that we've gone through it one more time, reviewed it all. Because we've made a lot of changes. There's a lot of wordsmithing in the last day and a half here. And we may look at some of it and go, wait, that doesn't make sense. So that would be my proposal, that we have an actual draft of all the changes that we can look at the next meeting. And then we would approve it and the statement of reasons at that point.
And this is Commissioner Fry, just to add to that. I like that idea. I'd like to see it redlined and read everything, all the changes in red, so it's obvious what we did.
Just one comment on that, since I'll be involved in preparing that. I need the transcript, and the transcript will arrive about 2 weeks from now. I mean, we have the Zoom recording, but that frankly would be kind of a misery to rely on rather than the transcript. So you would not be getting this document in the next few weeks. You would be getting this document probably closer to 10 days before your next meeting. But it would be closer to your next meeting than in the next couple of weeks, that's all.
Okay. So I believe Commissioner Brancard is saying now is not the proper time to have a motion to adopt.
I think we still may want to make some, tinkering with the words or something.
I think so.
This Commissioner Fry, what if we did have the motion and the vote, but with stipulation that we have a chance to review it at the next meeting?
I think that would just be messy.
Yeah, it's counterintuitive.
Although, then, Ms. Commissioner, there may be a point there. I'm looking at our rules. And we have rules on rulemaking, and it says that we have to make a decision within 60 days following the close of the record or the date the hearing officer's report was filed. So I think we may have to make some sort of decision now.
The other thing is you have a quorum right now.
I seem to, this Commissioner Fry, I seem to recall that in our rulemaking rules that there's a period of time where people can, I can't think of my words today, contest our decisions. And would we fall in as one of those parties to say, no, that's not what we had agreed to? If we vote today and we see the later version that's has all the changes.
So typically the window for an appeal of the commission's decision starts when you've made your final decision, and that would be the adoption of the SOR and the filing of the rule. And I think it's 30 days following that where they would go to the Court of Appeals. But that is out. If in fact I had misrepresented what their final proposal was in my hearing officer report or attachment A, I truly believe council would have reached out by email at a minimum, if not a motion, to say, you got that wrong. Well, we did have Ms. Nanasi yesterday mentioning that I had left out the name of one of her witnesses. I mean, they don't hesitate. They laugh sometimes that my last name is Orth, which in German means to correct. So anyway, so I don't believe, you have relied on inaccurate information about the parties' positions. You had all of their post-hearing submittals since December.
Let me rephrase my question because I've had a little time to think about it. What is the commission's, after, say we vote today, the changes are made, and we realize that A, one of the changes wasn't correctly made, or B, the change was made and we realized it presented a new problem we hadn't anticipated.
Okay, so at this point, I guess I would ask Commission Counsel to weigh in, because I didn't have reservations about the proposal from one of you to say, we're generally comfortable that we've deliberated through all the sections and want to adopt the petition with the edits and adjustments we've made during the deliberations. And we will come back at the next meeting with a review of the red line and the opportunity to, reopen in order to make further adjustments based on the latest draft, right? And the then have to approve the SOR. Commission Counsel, does that give you pause?
No, it does not.
I don't know if you could hear. Okay.
This is Chair Thompson. Commissioner Brancard said that the commission has to take action within 60 days.
I think I have a resolution.
Well, let me just point out, within 60 days of the hearing officer's report. The hearing officer's report was submitted on docketed matters, end of March 24th.
Okay.
So if our next meeting will be second Tuesday in May, I don't know what date that's. So I think we've got the 60-day window. We're in compliance with that.
Okay, because what I was going to suggest is that the hearing officer finalize her report by submitting the proposed changes. But anyway, I think the more scary deadline is the deadline in the Rules Act that says once we act on the rule, we have 15 days to file it with the Record Center. Okay, so in other words, we have to be absolutely sure what we're adopting before we say yes to it, because that will trigger a statutory deadline and really send our staff scrambling, figure out how to get something filed with the Record Center.
All right, let me offer a reply to that. I've been involved in a lot of rulemakings in the past year, mostly actually with EMNRD. And the staff at EMNRD have told me several times that the Record Center will not even accept their rule with the rule transmittal sheet unless there's an SOR appended to it. And so I believe until you adopt the SOR, that 15 days does not start running.
Okay. So it sounds like we're okay with the statutory deadlines. Anything else to discuss today? So this is a continuation of our regular meeting. Agenda item number 6 is to set a date for our next meeting. We normally meet on the second Tuesday of each month, which would be May 13th. And so at that meeting, we will have the final red line markup. We will have a statement of reasons, and we will, at that point, we will be in a position to accept the rule, approve the rule, adopt the rule, whatever we do. All right. Further questions, comments? We're about to lose a forum. Grab her and hang on to her there, Mr. Brancard. Again, thank you very much. This has been an experience going back well over a year. So thanks to the commission. Thank you to the hearing officer, commission staff, and the participants, parties. It's great. And I hope we can still be friends. I take a motion to adjourn.
I move. Second.
All right, we're adjourned.